Hello, I'm attorney Dan Marr from the Nashua, New Hampshire law firm of Hamlin and Kerrigan. I've been practicing here in New Hampshire for about 38, 39 years, and in the Commonwealth of Massachusetts for about 28 to 29 years. I'm going to be discussing today in business contracts what we call choice of forum clauses. I talked in other blogs last week about the importance of limitations of liability, everything from your ability to terminate a contract to the limitation of damages. Those are extremely important in a contract to negotiate. I also talked about in the week before that whether you have a provision that says prevailing attorney's fees. Prevailing party gets the attorney's fees. Basically, the loser has to pay the other side the attorney's fees. And there's some strategy reasons for both of those situations depending on where you're at. And I've discussed that in the blogs in negotiating as to what you want, whether you want a limitation of liabilities, whether you want prevailing party attorney's fees. All of that matters. It's not just everyone wants one of those. You want to really look at that, and I've talked about that in the vlog. Now I'm going to be talking about if there is a dispute between people in a contract, you have things what's called a choice of forum clause, which says this is what we're going to be dealing with, how we're going to resolve this dispute. And sometimes it can range from saying we're going to go to court, but we're going to go to court in this state versus that state. Or we talk about the other alternatives to dispute resolution, mediation and arbitration and the like. So let's talk about that today. So first, in this discussion you have are you going to be discussing which place you have to go? If you're a New Hampshire company and you are dealing with somebody in California, you may not want to go over to the West Coast to have a litigation in regards to the matter. So if you have the leverage, you might want to state that it has to be in New Hampshire. That would be a normal circumstance. Most people like to be in their home area so they don't have to travel out to court. So that's something to think about, and depending on your leverage, you want to think about that aspect. But more importantly, sometimes is how you want it resolved. Do you want to have the ability for either side to have a jury trial? You can have a provision in the contracts that very clearly say between the two businesses they waive all rights to a jury trial, and that may very well be enforced between two businesses. Sometimes not as much with consumers, but often with businesses they can waive their right to a jury trial, which just prolongs the process. And in a business case, I often find you don't really want a jury deciding the fate of two businesses. You want my own experience, I find that the judges are better in understanding the law rather than the judge explaining the law to the jury and the jury making decisions. And a lot of the business cases, I prefer to have a judge make the decision. So in that situation, if I'm dealing with a judge versus a jury, I prefer to waive the jury trial rights in the contract, and it also gets us quicker to a resolution if it's what we call a bench trial, being a judge-decided case versus a jury-decided case. But then the next part of this is, do you want arbitration? There's mediation, which people they may put into an agreement that says you have to first try to mediate, and if you can't mediate, then you go to arbitration. Maybe that's the steps you deal with: negotiation, mediation, arbitration. It'll prolong the process, but you can do that. I find myself, if you can't resolve the matter through negotiating, and you don't voluntarily go into mediation, then it may not be worth as much, but mediation can be very helpful. Arbitration, though, is where there's somebody that's not a current judge in the judicial system that's making the decision for you. It could be a retired judge. It could be somebody else that has a great deal of litigation experience as a lawyer in the thing, or it could be something specific, or be a person specific to that niche of your business that really knows their stuff, and they've done arbitrations before, so they know how to resolve disputes. But they're going to be basically your judge. And in that situation, that can still be very helpful. I myself and officers of companies that have to deal with their investors and stuff, if I'm going to be dealing with arbitration, I prefer to have a situation where it's going to be the arbitrator is going to be selected by an arbitration organization. Like JAMS is a bunch of retired judges that are very, very competent, and they do mediation and arbitration. If it's going to be selected by them, or the American Arbitration Association is going to pick the arbitrator. And you can actually have three arbitrators, or you can have one arbitrator. You can say whatever you want. Generally, one arbitrator is going to be a little bit easier to deal with, but in larger cases, sometimes people want a panel of three arbitrators to deal with. So you discuss that up front, and you address that in your agreement. Myself, and for the officers of the companies that have to report to investors, I do prefer not to be a selected arbitrator, because somebody in the litigation is going to come in second. Somebody's going to win, somebody's going to lose. And the officers of your company, having explained to their investors, or frankly even the attorneys, saying, answering the question, well, why did you pick Mr. Smith or Ms. Jones to be the arbitrator? You're not picking them. They're the organization's picking them, just like you would in a court system. You don't get to pick your judge. I get concerned when there's a business court that only has one judge. You got the same issue of if you select the business court and you had the opportunity to select that business court, then the question is if you don't do as well as you were hoping to do in the litigation, your investors may very well be considering, well, why did we pick that person? And you don't know that until you have the case, but still it's helpful to have somebody else pick that decision maker for you. So I've dealt with these cases quite a bit. I'm happy to talk to you about these. I've litigated and arbitrated in both New Hampshire and Massachusetts for many years, and I'm here at 603-883-5501, phone number 603-883-5501. If you're interested in this topic or other topics, again, including those other business situations of attorney's fees and limitations to liability, my vlogs are all available. I do weekly vlogs, and they're all by topic. If you go to our website, nashwalaw.com, and you click on my bio, you can go to our YouTube page, or you can access the YouTube page directly from YouTube and take a look at all my vlogs. I've been quite a few of them because I've been doing it for a number of years, weekly by topic. Look forward to working with you. The opportunity arises. Thank you.